Hello, this is Anthony Verna of the Law Offices of Anthony Verna. I wanted to talk to you about 4 mistakes that people generally make in filing trademark applications when they do it themselves. The first one seems a little obvious, but might not be, and it's really filing for the incorrect mark. And although a lot of people are looking for trademark protection, and federal trademark protection is fantastic, you get to go into federal court, you get to ask for attorney's fees, you get to ask for very high damages for a federally registered mark. But you have to get the right mark, unfortunately, in your application. Sometimes companies are just not sure of what the trademark really is. We think it's X, but in reality, when you're using Y and it's something different from what you filed, it's a totally different mark. Very unfortunate, but it does happen. A lot of entities also put the incorrect owner. For example, a person will say, I am the entity registering the mark, when in reality a company is using the mark, not a person. People can use trademarks. That's perfectly fine. I'm a sole practitioner. So it's perfectly fine for a person to use a trademark, for a person to be the business, but you just have to know if it's the business or the person that's actually using the mark. Another one, and this one can be very tricky, the incorrect date of the first use of the mark. It's very important because we need to establish when the mark was being used, how long that's been used in business. And if the incorrect date is there, then we're telling the Patent and Trademark Office incorrect information. Also, the incorrect description of goods and services. And I think this is what I see the most. When a company files for the federal registration, the application or the tendency for a lot of people is to put all the goods and services that anybody can think of on the application. And I understand that. You know, if you're selling spatulas and forks, you might want to see knives or spoons or something to that effect. However, that's not always the case. For example, like I just said, if you are selling spatulas and you are selling knives and you put down forks and spoons, that's all logical. Unless you're not really selling knives or forks and spoons. The goods and services must match. There's nothing more important than the goods and services actually matching. Somebody once asked me, I'm making peanut butter, and I'm not planning to have jelly made for another year and a half. But it's in the plans. We have the recipe. We want the peanut butter to sell first before the jelly. And I understand that. Again, business decision. You have to file twice. Why? Because you're not actually using the goods and services that you're claiming at that point. And if there's going to be such a gap, then your peanut butter is one application and your jelly is another application. And otherwise, the Patent and Trademark Office can look at it as if it's fraud upon the Patent and Trademark Office. And if an application is incorrect for one reason or another, it could be canceled. We don't want that to happen. So avoid any of these mistakes. Speak with an attorney, of course, but avoid these mistakes. And hopefully, by avoiding these mistakes, you'll avoid other issues down the road. No guarantee. But these 4 issues are very important because they go straight to the heart of what we call fraud upon the Patent and Trademark Office, and they very well could lead to canceling. Again, my name is Anthony Verna. You can find me at nyctrademarks.com and nyccopyrights.com. You can give me a call, 917-348-0108. Thank you very much.